Greetings, everyone. My name is Paul Smith. I'm a professor for practice at Georgetown Law, where I teach, among other things, LGBTQ civil rights. And I'm happy to be joined today by my Georgetown colleague, Marty Lederman, as we debrief everyone on Monday's momentous Supreme Court decision in the Bostock case. So during this hour or so, we're going to talk about the case, what it means, how it happened, its effects on the interpretation of other laws, a lot of stuff. And we also want to talk about what our audience is interested in. So we're going to take questions, which hopefully you can put in the comments on Facebook, and they'll get to us, and we'll try to answer them as we can as we go along, particularly toward the later part of the conversation. So just to set the stage, Title VII of the Civil Rights Act of 1964 is the core law that prohibits discrimination in employment in this country. It prohibits discrimination based on race, sex, religion, and national origin. And for many years, advocates of LGBT equality have been trying to get Congress to add prohibitions on discrimination based on sexual orientation or being transgender. That bill has been pending in Congress for many, many years, but it turns out that those protections were already there. The 6-judge justice majority, in an opinion written remarkably by Justice Neil Gorsuch, held in the Bostock case that discrimination against LGBTQ applicants for jobs or employees based on their sexual orientation or being transgender necessarily constitutes discrimination because of sex and therefore violates Title VII. So Marty, can you explain how Gorsuch came to that maybe not obvious conclusion and whether you find his reasoning persuasive?
Sure, Paul. This is a pretty exciting day or a pretty exciting week.
Indeed.
It's a pretty important landmark decision, as you mentioned. There's 3 cases, actually. Bostock is one of the 3 cases the court decided in one opinion.
Right.
Two of the cases involved gay men who were fired by their employers. One was a public employer in Georgia. The other was a skydiving operation, a private skydiving operation in the state of New York. And they alleged that they were fired because the employers discovered that they were gay or because they came out as gay in the workplace. The employers denied that that was the reason that they were fired. But before it got to a jury trial on that factual question, the employers also said, even if we did fire them because they're gay, that doesn't violate Title VII. Neither employer, notably, has a policy against hiring gay and lesbian employees. So that's one thing to keep in mind. The third case involved a funeral home in Michigan in which Amy Stevens, who tragically died a couple of weeks ago, just before her great victory, she had been working there as a funeral home director for many years. And during the latter part of which she was transitioning to present as a woman. And told her employer that, and the employer was a religious owner, and he was opposed to this and was very worried about how she would affect the clientele, the grieving families. He assumed that they would know that she was transgender, although the record is completely silent on that, and there's no reason to think that that was true. But one way or the other, he basically said to her, "You being what I consider a man, you must present in the workplace in the way, according to the dress and behavioral code that I've set up for women and not the one for men. So you can't dress it. You can't have women's hairstyles. You can't dress in a dress. You have to dress like a man." She said that she refused to do that. That would be inconsistent with her transition, and he fired her. So one thing that's interesting about the court's decision is the court sort of ignored all the facts of all the cases. It really
treated the question in the abstract, totally.
Right, they treated the question in the abstract without any of the intricacies or interesting questions raised by the cases. They treated it as though we're talking about employers who simply have a policy, no gays, no transgender persons allowed, and asked whether that is consistent with Title VII or whether it's prohibited by Title VII with respect to a particular person who's fired according to that policy. There's something a bit artificial about that. I just want to set it up that way because there are very few employers in the United States that have such at least open policies.
All right, but it's no different from a race case or some other kind of discrimination case where you prove that that was the real reason, even if they haven't written it down.
Right, but I'll get to it in a little bit. I'll get to why Justice Alito's framing of it that way is somewhat artificial and wrong. Anyway, what Justice Gorsuch said was simply, if you look at Mr. Zarda, for instance, he's fired allegedly because he's attracted to men. A female flight instructor who was in all other respects similar to him, attracted to men, would not have been fired, or that's, the case comes to the court on that presumption. And therefore, men and women with identical characteristics are being treated differently. That is a form of sex discrimination. You don't need to get into any intricacies, said Justice Gorsuch, about whether sexual orientation itself should be deemed sex, right, under the terms of Title VII. It's simply the case that you're treating men and women, even if you assume their biological characteristics determine whether they are male or female, you're treating them differently based on those biological characteristics. Everyone agrees that at a minimum, that includes sex.
So isn't the response of Alito and Kavanaugh, at least substantial, which is to say, you're not firing him, Zarda or Bostock, because he's a man instead of a woman. You're firing him because he's gay. And that's a different thing.
Right. So they focus on two things. One is that idea that the motive isn't sort of animus against women or against men, against or one rather than the other. That the motive is a more generalized opposition to homosexuality or transgender transition, writ large, that would apply equally. The comparator that they say is relevant is, would a lesbian have been treated the same way as a gay man by those two employers? Or would a man who wanted to present, would someone who had been designated at birth as a woman who wanted to present as a man have been treated the same way by the funeral home? And they say if the answer to that is yes, which they assumed it would be, then men and women are actually being treated the same. They're both being treated disfavorably if they are attracted to someone of the same sex, or if they dress in a way inconsistent with traditional sex roles, either way in the Stevens case. And from that framework, they say, sex really doesn't have anything to do with it, or the sex of the individual was irrelevant. And Justice Gorsuch says, no, and just as a textualist matter, you have to consider their sex. I don't know. I'm curious what you think, Paul. I'm not altogether overwhelmed by the very formalistic logic in Justice Gorsuch's opinion, or many of the hypotheticals or analogies that he draws in response to Justice Alito's framing. I think there was a better way to address Justice Alito's hypos, but I'll take it. Right? I think Gorsuch got to the right answer using reasoning that was pretty much right, but not completely responsive.
It's the reasoning that the advocates gave him, which is to say you have two equal people in the workplace, a man and a woman. They're both attracted to men. One gets fired, the other one doesn't, and it's because the one who got fired is a man attracted to a man instead of a woman, and that's sexual differentiation. The response that, well, but he was fired not by virtue of his gender, but by virtue of his homosexuality is something that the court could easily have latched onto. In fact, I expected that position, the Alito-Kavanaugh position, to prevail, frankly, in the end of the day. So it was interesting that Gorsuch went quite a ways with this sort of literalistic argument as it's characterized in the dissents, and got Roberts to go along with him. I mean, it was a 6-3 decision. I don't think
no one expected it to be 6-3.
No, I mean, it's really interesting, isn't it? Do you think that part of what's going on here is just the court following the opinions of the American people, that strongly the American people in the polls oppose discrimination against people just because they're gay or transgender?
It's a good question. I always hesitate to sort of psychoanalyze the justices. I think there's probably a confluence of many different factors
You
involved.
do not. You do that all the time. Come on.
Not in public though, Paul. Not in public. But I actually think that to a certain extent, one of the factors, at least for Justice Gorsuch, is he thought this is where his form of statutory textualism took him. I think he genuinely believed that, and I think Justice Kavanaugh thought otherwise, using a very similar form of textualism. But also, yes, I think they probably thought that they weren't willing to write this, but the broad purposes and objectives of the 1964 Civil Rights Act, we now understand them as really applying in these situations, right? As you were just saying, to a certain extent, it follows from a bunch of cases the court has decided over the first 50, 60 years of the Civil Rights Act. So when the court decides that an employer cannot, for instance, treat a woman worse because she's not conforming to female stereotypes in the workplace, and if you accept that, that wouldn't become more acceptable if the employer treated a male employee just as poorly for acting in an effeminate way in the workplace. Dual stereotyping would be double discrimination. It wouldn't be non-discrimination. Well, here it's almost worse. Here it's the employer using two different stereotypes and treating, even if it treats gay men and lesbians both poorly, hypothetically, it's treating them poorly because of stereotypes about what they should each be doing in the bedroom or in the family, outside the workplace. Right. And if anything, that's even less justifiable from any normative perspective reflected in the statute than firing them for the way they comport themselves in the workplace.
I mean, in many ways, the key move that leads to this conclusion was the one they made a long time ago to say, you can violate Title VII by mistreating one woman because of her sex, even if you don't mistreat women as a class at all. And the sexual harassment cases were the ones where that move really becomes clear. If a single female employee is fired for refusing sexual advances, that's a violation of Title VII, even if the employer is a model employer of women in general. And so you don't look at it as on a class basis. You look at the particular employee's experience and say, if this employee were a man instead of a woman, would the same treatment have occurred? And Justice Gorsuch correctly points out, no. That is the way he gets to his conclusion. And in the end of the day, of course, I agree with you. It doesn't matter how they got there. The most amazing thing is that they got there. Maybe we ought to just pause to celebrate what an enormous change in the position of LGBTQ people in the economy and their lives this is. I used to co-chair the board of Lambda Legal, and they run a helpline, and they would get hundreds, if not thousands, of calls a year from people in the 29 states that didn't prohibit this kind of discrimination and asking for help, and they would have to tell them, this was true until Monday, there's nothing we can do for you, and it's not illegal for your employer to find out you're gay or lesbian or transgender and fire you for it explicitly. And so the reason that this was such a long sought remedy to have the statutes rewritten to protect against this kind of discrimination is very obvious. This kind of discrimination is quite rampant. But now we have a 50-state solution, and it is, I think, it is real watershed day for people involved.
I agree. I agree completely. It is a watershed day. And even more than that, if the court, this current set of justices or a future set of justices, were to take seriously the rationale of the Gorsuch opinion, which was an opinion for 6, as you point out, it would almost certainly have a dramatic impact on a bunch of other statutes that use similar language, not necessarily all anti-discrimination statutes. Gorsuch points out that there's a variety of textual formulations, and some of them might not follow from, the same result might not follow. But Justice Alito sort of does the homework for the plaintiffs.
It's a long list.
With this long appendix citing all of the statutes that he thinks are going to now protect LGBTQ people across the land, for which I'm very grateful that he had one of his clerks run all that down. I'm not sure they will all turn out the same way, even with the same array of justices, but certainly many of them will.
I don't know how
will have an impact beyond the workplace.
Difficult, I would think, to differentiate them. I mean, unless there's a statute that requires that it be the primary motive or the only motive or something like that, it's going to be, given the way Gorsuch wrote this and for 6 justices, it's going to be very difficult to distinguish it in some other statutory context or even in the constitutional context. The Equal Protection Clause of the 14th Amendment, of course, prohibits discrimination based on sex. That's the principle that Justice Ginsburg so famously got the court to adopt, that kind of discrimination by the government is presumptively unconstitutional under heightened scrutiny. And it's pretty hard to say that you wouldn't apply that same principle now to discrimination by the government against transgender people or against LGBT.
That's true. I have a feeling Justice Gorsuch would say, because the words sex, because of, and discriminate, none of them appear in the 14th Amendment, ironically enough.
Yes.
He would say his statutory textual analysis simply doesn't apply. But I think it's virtually inevitable. It seems almost unthinkable now that the court wouldn't apply heightened scrutiny to discrimination by governmental actors on the basis of sexual orientation or transgender status, or at the very least, and I actually think this was true before, I don't know, I think you might as well, even before this week, I think it's so unlikely that the court would hold that such governmental discrimination would have even passed rational basis muster in 95 out of 100 cases. You know, and
it was already de facto, despite the way Kennedy wrote all those cases from Romer to Obergefell, it was already de facto pretty clear that government can't discriminate based on sexual orientation. They can't say we don't hire gay cops or whatever. That was really already well established. But boy, to extend that into other contexts is, you know, it's nice, and it will have an impact on transgender discrimination cases under the Constitution, including the whole raft of cases that are sitting out there challenging the exclusion of transgender people from the military. You'd have to say that has to be heightened scrutiny as well now. I don't see how you get around that. And that maybe they can pass heightened scrutiny. They will try by saying, well, we have strong interests in saving money or unit cohesion or all the other arguments that they trot out in that case. I wouldn't rule for them. It's, you know, who knows, the Supreme Court might, but they're going to have a higher burden.
You wouldn't rule for the government, for DOD, I mean, for the Department of Defense, right? Yeah. I think, so the interesting case is that the court, so I filed a brief in the case trying to address the issue that was bothering a lot of people and that the side was using to try to get the justices to rule the other way, which was the specter of restrooms on the one hand and dress codes on the other. So especially with respect to transgender persons, the irony there is in both of those cases, there's no question, this is what we wrote, that's because of sex, right? The bathrooms say men, women, right? Those are expressly sex-based segregations. A dress code says men shall dress X and women shall dress Y. Those are on the basis of sex. And so now the question becomes, are they justifiable distinctions on the basis of sex? And what we wrote, and Justice Gorsuch hints at this in his opinion, that he basically agrees that's going to be on the basis of because of sex. The remaining question is whether those policies discriminate, and he cites a case saying that some forms of sex-based distinction or segregation might not generally injure the people who are treated differently. And so what we argued, and I hope this is the way it's going, is those policies will be generally okay. You can still have single-sex restrooms, dress policies, but as applied to individual employees who would be deeply injured by those policies, namely transgender persons, you can't apply it as to them.
No, I think it's pretty clear that under this law, you have a very substantial argument if you're a transgender employee who's told, you know, you're Amy Stevenson told you have to continue using the men's room instead of the women's room, that's discrimination against you based on transgender status, not accepting your identity, your new gender identity is discriminatory, and you have to have access to ladies' room. I would think that's a pretty strong argument.
Yes, he goes out of his way to say we're not deciding that, but I think he drops enough hints that I think the lower courts will begin to rule in favor. He rejects the rationales that the lower courts have used for the last several decades to rule against transgender person and employees. And I think the tide will turn on that quite quickly. You know, there'll still be hard cases with privacy, like in locker rooms and the like.
Yeah.
But as we said in another brief, architecture rather than law will take care of that one.
That's exactly right. We have a question about how it is that Gorsuch would have ended up writing this opinion rather than one of the more liberal judges or the chief or whatever. Do you have a theory about that?
So if the chief was originally in the majority, which no one expected, he would have been the justice to assign the case, and he would have assigned it to Justice Gorsuch because he would have heard that Justice Gorsuch was in the majority. He would have understood that Gorsuch's opinion would be probably narrower and more to his liking than Justice Ginsburg, if Justice Ginsburg had herself assigned the case. But quite frankly, even if the chief had been in the dissent and Justice Ginsburg had been the assigning justice, I think she would have assigned it to Justice Gorsuch. She needed to hold his vote. And the four more liberal justices were quite willing to go along with an opinion that I'm sure none of them would have written it that way. But they are perfectly fine because they think the result is actually the correct result. So I think whether it was the chief or Ginsburg, Gorsuch, once he was on board, he was going to be writing this opinion.
And I guess it'll be a long time before we find out who did the assigning here. It's very hard to read the tea leaves. It's perfectly possible that Roberts came along later on or changed his view. I mean, it's
possible. There's a real inside baseball question that oddly in all of the October cases, the chief did not assign himself any, or he didn't write any majority opinions. No one quite understands why that might be. It could be he was already preparing for what looked like an impeachment trial down the road, or that he was saving, he knew that the next month, the DACA case was on the docket and he was going to take that for himself. And that was going to be a bear of a case to deal with. It has many, many different legal questions. So it could be that the chief just decided, Justice Gorsuch is the one to write it. I don't know. Who knows? Maybe our grandchildren will see the papers and they'll find out. I'm afraid we won't, probably.
I guess the other thing I would note is I don't think this decision is vulnerable in any way. Given that it was joined by two very conservative justices, the court's not going to rethink this, not anytime soon. And it seems inconceivable that Congress would try to overrule this decision by taking gays and lesbians and transgender people out of the protections of Title VII now that they have been given those protections. I mean, just almost unimaginable that Congress would go out of its way to take back protections that most Americans strongly support.
I think that's exactly right. Let me ask you two questions based on that. First, it's very interesting. There was a lot of hostile reaction among some conservatives, including Senator Hawley, for instance, and others, about Justice Gorsuch and Chief Justice Roberts betraying we've been behind this judge picking for 30 years, and this is what we get. This is where the textualism gets us. Calling it the end of the Federalist Society movement and the end of the judicial project of the conservative right. I think it's way more complicated than that. I think the judicial project on the conservative right consists of several different strands, right. Some of which are perfectly fine with this, and in fact celebrating the textualism that they used. But obviously the moral right, the religious and moral right was very shocked and very concerned about it. And I don't know what it's going to mean for that coalition. And I'm curious whether you have any thoughts on what it might mean for that.
I don't have any great analysis of how the right stacks up on this thing. I would, while I give this answer, encourage anybody to give us any questions you want in the comment section. We have about 20 minutes or so more. But it is, I think, going to have an interesting impact on political salience now, because the symbolism of Gorsuch as the great thing that Trump gave to his conservative followers is already watered down significantly. And of course, it may look different again when the abortion case comes down in a week or so. But
right. So we have the abortion case. We have 3 religion cases this term: abortion, 2 presidential subpoena cases.
yeah,
A case about the unitary executive, and those, and especially the 4 sort of moral cases that are left, might very well all go in the so-called conservative direction.
yes, it seems likely. My own speculation about Gorsuch is that he sort of liked the idea of finding a case in which he could follow his methodology to a liberal outcome. It buys him years and years of credibility as a principled justice, in much the way that Justice Scalia would always bring up the flag burning case as a case where he reached an outcome he doesn't support ideologically, but it was the right answer under the original intent of the First Amendment, that you can't punish people for flag burning. And so, I mean, I think this is a very interesting moment. And what Gorsuch did, we have several questions about this, is he left open the possibility that the people he cares about, who are going to be potentially unhappy about this, people with religious convictions, will have defenses from discrimination claims based on religion. He notes that Title VII itself has some exemptions for religious institutions or for ministerial employees. And more importantly, he refers to the Religious Freedom Restoration Act and says that is a possible defense to Title VII liability. What that act says is if a federal law ends up imposing a burden on somebody's religion, the government can't do it unless it has a compelling interest that it can only serve in that way. Puts the shifts to enormous burden of justification. There actually was a RFRA claim, as they're called, in the Harris Funeral Home transgender case in the court. That issue just didn't get up all the way to the Supreme Court. But it was rejected in the lower court, in the Sixth Circuit, on 2 grounds. One, that there's no real burden shown on religion simply to have somebody in your employ who's transgender. It's not quite the same as the Masterpiece Cake Shop guy saying, I feel like I'm complicit in your sinful wedding by having made the cake.
Although the owner of the funeral home did, not very well, but made the claim that if Ms. Stevens presented as a woman to the clientele might perceive him as approving of transgender transitions, and that would be inconsistent with his. It wasn't very thoroughly vetted in the case.
Right. I mean,
it's
lurking. Fairly weak complicity claim, as they're called. And then the court went on to say, and there's a compelling interest in any event in preventing discrimination in the workplace. An interesting question that will be hanging out there until the court finally has an LGBT discrimination claim subject to a RFRA defense. And we find out, if you go back to the Hobby Lobby case, which is the case in which the Supreme Court allowed a religious corporation, so to speak, in the Hobby Lobby company to not provide contraception that it disapproved of to its employees because of RFRA. There's a discussion there in the Alito opinion that says there's a compelling interest in barring racial discrimination in employment, quite clearly leaving out other kinds of discrimination and leaving open the question of whether or not a federal law that bars discrimination based on sexual orientation does in fact serve a compelling interest. We'll find out that answer quite a bit sooner now that we have Title VII suddenly has been understood to apply to sexual orientation discrimination. So, Marty, are you with me or are you froze? Looks like I've got Marty a little bit frozen. Hopefully he'll reappear. Are you with us still, Marty?
I was frozen there. Sorry, Paul. I'm sure you gave all the answers there in that 30 seconds.
No, I was talking a little bit about religion and Religious Freedom Restoration Act.
Yeah, no, we're getting a lot of questions from viewers about possible religious exemptions, and you're right. Gorsuch suggested they could come in 3 different. One is under the statutory exemption in Title VII itself, which up till now would not, it has not been construed to provide an exception in these sorts of circumstances.
No, you wouldn't
But
necessarily.
you never know what the court will do with it. The second would be RFRA, as you point out. And the third would be the free exercise clause,
Right.
which, there's all sorts of theories under that. And that's implicated in a case the court will be hearing next term involving foster care services by Catholic Social Services in the city of Philadelphia. Very
Right.
important.
This is the Catholic Social Services Agency that refuses to provide foster children into same-sex couples' households.
Right. It turns out to be a very factually complicated case. We'll talk about that next year. We'll come back and do that. And there's a case that might be decided in the next 2 or 3 weeks, nominally called Little Sisters versus Pennsylvania, or Trump versus Pennsylvania, involving the Trump administration's regulations that grant broad religious and moral exemptions to contraception coverage. And that one of their arguments is that RFRA should be construed very broadly, and that we don't. So that's one to keep an eye on. So the Gorsuch, Kennedy, Alito, Roberts, and Thomas, they're all very sympathetic to religious exemptions under all these different theories. And I think that's an area that we'll obviously be discussing for many.
Yeah, you'd have to think that foster care case is not going to be another big day for gay rights in the end. In all likelihood.
Remains to be seen. I think it's going to be framed differently by the time it's argued, but we'll see.
So. We have a question that I know you have an opinion on, Marty, which is Justice Kavanaugh's dissent, in particular, the last paragraph of his dissent, in which he talks about how LGBTQ people ought to take pride in this outcome, even if it's legally illegitimate.
I've been publicly and privately speculating a little bit about Justice Kavanaugh. I found it really interesting that he didn't, once he saw that Gorsuch and the chief were in the majority, he could have joined them, particularly since his textualism is similar to, although not the same as, Gorsuch's statutory interpretation theory. And he decided not to, and it could have, knowing that it would have given him some goodwill among certain communities and certain constituencies, knowing that it's only a statutory case, he wouldn't be making any grand constitutional law to go that way. And he decides not to. It might just be a principled thing. It might just be that, this is the way he read the statute and he didn't think he could get there. But he goes out of his way in the last paragraph. Unlike Gorsuch doesn't say, like Scalia, this is an outcome I regret. He doesn't say anything about the outcome. Alito is obviously furious about the outcome. Apoplectic. That the words he uses are quite extraordinary to criticize his fellow conservative jurists. But Kavanaugh goes out of his way to say, I think the court got it wrong, but nevertheless, this is an important victory for millions of persons who have worked hard for many decades, exhibited extraordinary vision, tenacity, and grit, who can take pride in today's result. It's this amazing paragraph to say, this is my Scalia moment. I regret that I come out against against the plaintiffs here. But what's really conspicuous is that throughout that paragraph, he talks only about gay men and lesbians with not a word about transgender persons. And I don't want to speculate about why that, it would have been so easy to add that as well. But I think he's much more comfortable with equality for gays and lesbians than for the transgender question. And I think that might reflect not just Kavanaugh, but many religious and other people who have become, in the last 10, 20 years, yeah, of course there should be gay rights. We shouldn't treat gays and lesbians differently. But they're not sure what they feel yet about transgender status. It's a newer phenomenon to them, or a more, one that they haven't seen or been as familiar with. And they're worried about all these hypotheticals that turn out, in effect, really not to be very troubling. But, Gorsuch raising the locker rooms and the dress codes and all of that. And we'll see whether there's a split in the law on these questions. Certainly Kavanaugh seems to have a split in his sympathies on these questions. What other questions do we have from our?
That's what I'm looking at right now. One question about the Fair Housing Act of 1968 and whether that'll be automatically treated the same way. I think you probably have, with each of these statutes, you're going to have a case in which the court decides if there's any way to distinguish it. But I think generally speaking, those core civil rights acts are going to end up being interpreted the same. It's hard to imagine that you would distinguish.
Yeah, so that gets, I had two questions for you. The second one was, I don't know if this is ironic or simply interesting, this multi-decade project of getting Congress to enact what's now called the Equality Act, right? To provide equality for LGBTQ persons across many different federal statutes. The impetus for that is now sort of going to be, it's not going to be high on anyone's hit parade because there's going to be far less need for it. One day I think that such a statute will be enacted, but do you think that it's kind of going to take the air out of that project?
I think it may for a while. I mean, it obviously wasn't going anywhere in the current Congress anyway. But if you imagine the Democrats controlling both houses of Congress and the presidency, the question is, does that become one of their priority bills to pass on top of all the other things that they have on a list, fixing democracy, making DC a state, whatever their wish list is? And I can imagine them going ahead and passing it. But the alternative scenario is, once you start enacting a new statute, you end up with lots of fighting over religious exemptions. And it's easy now for Congress to say, well, we'll just let the court figure those out. We don't need to opine on that.
Right. It makes impossible any so-called compromise statute, but I don't think that had much of a chance anyway these days.
Yeah.
A statute that would provide broad rights, but with fairly robust religious exemptions.
Yeah. Well, I mean, ultimately that seems to me the wrong answer. Having lots of places in the business world where people are able to exercise religious-based discriminatory intent is just not the right answer. People should be able to do that in their homes, their school, their churches, and their clubs, but not in the business world. People should be able to walk into a store and secure in the idea that they're not going to be discriminated against. So, why would you want to pass a law that actually endorses the ability of businesses to discriminate? It just seems.
And it's turned out to be, just a sort of political and economic nightmare in those jurisdictions where it has been proposed. The Chamber of Commerce is the first group up saying, that's ridiculous. We're not going to do that. No one will come to our state for business. So we have a question from Perry about whether this 6-3 breakdown, what does it presage for the other high profile cases to be decided this term? Is it the beginning of a shocking liberal turn, or?
I think it's quite the contrary. I think the court, the people like the Chief and Gorsuch are probably really happy to have a case that shows the court looking principled, nonpartisan, apolitical, and then gives them lots of cover for other things that they probably intended. Certainly the abortion case and stuff. It's hard to imagine. We'll see.
So I think the three religion cases will probably, at least 2 out of the 3 will come out in favor of, and we don't have time to get into what each of them is about. Will probably come out in the pro-religion side in one way or another. The foster care case next term, I think, is more complicated and more difficult because it's a contract. It's a city contract to perform functions that the city itself would be
public function. Yeah,
public functions. Abortion and DACA are 2 wild cards, I think, because you can imagine the chief striking down the abortion statute in Louisiana simply on stare decisis grounds, saying it's governed by the whole women's health care case, a case that's virtually on all fours coming out of Texas, but saying a lot in the opinion about his doubts about Roe and Casey and sort of signaling a continuing 5-justice majority that is hostile to Roe. I can imagine that, or I can see him, trying to draw some distinction. And in DACA, just so people know, there's several issues in the case, and there's different ways that they might rule in favor of the Trump administration if they do, which is what most people expect. The narrower decision would be to say that the case is not justiciable and they don't reach the merits. a little bit less narrow than that would be to say that it was within the purview, within the power of the Trump administration to rescind DACA. The most aggressive decision would be that DACA was not statutorily authorized to begin with. The Obama administration overstepped when it initiated DACA. That would be the most dramatic, because it would mean that a Biden administration, for instance, could not reinstate DACA without getting Congress to pass a new statute. So I think even if you think that DACA will probably come out against the Dreamers, something that will probably have some political impact, how the court rules will make a big difference, I think, in that case.
So just to conclude, why don't we spend a couple minutes talking about textualism and how people on both sides of this case think of themselves as textualists, and how the distinction between, as one of the questions asked, between Kavanaugh textualism and Gorsuch textualism. And I mean, ultimately, Kavanaugh says, nobody in 1964 ever even imagined that this was protecting people for being discriminated based on being gay or transgender. I'm not sure the concept of being transgender was even something people were aware of in 1964. To be gay was to be a criminal or to be sick. And so people, the ordinary meaning of the word, says Kavanaugh, would be something more narrow than this. And that you're kind of going out of your way to find a literal violation, but it's not common sense to read the statute that way. What do you think?
Yeah, so I've been asking people about this. It seems to me, this is going to get pretty in the weeds for those of you who don't follow all the various iterations of originalism and textualism. The academic right and the judicial right has been said to abandon a form of originalism and textualism that asks about what the legislature or the framers expected their law to do. You don't look at original expected applications. You look at text, and that's what Gorsuch purports to do. I find Kavanaugh's so-called textualism to be virtually indistinguishable from going back to the idea of looking at the original expected applications. And he does it in a gentle way, but as you and I were talking, Justice Alito does it in a much more aggressive way, right? He's like, this is just inconceivable. And he goes through and spends dozens and dozens of pages in appendices that broke the server at the Supreme Court, showing that in 1964, not only couldn't anyone imagine that the statute would be read this way, but the entire legal firmament was opposed to homosexuality, treated it as an illness, as a crime, and the like. It's just inconceivable. So he uses this metaphor that Justice Scalia was fond of, that you don't assume that Congress, meant to hide elephants in mouse holes. It didn't, this wasn't hiding in the interstices of this language in the statute in 1964, this huge thing, this elephant. Justice Gorsuch comes back and says, this isn't a case of elephants in mouse holes. This is the elephant that's just been standing right next to us, but we just haven't seen it until now.
It is a fascinating case about just plain old craft of statutory interpretation. It'll be taught in classrooms in law schools for quite a long time. Looks like we have one last question maybe we can try to address, Marty, which is what's the breadth of the decision under a general scheme of at-will employment? How can workers actually use this ruling to protect themselves?
So Title VII doesn't protect workplaces with fewer than 15 employees, which are generally, we tend to say those are governed by at-will employment under state law. You'll probably know more about this than I do, but I think it's the interesting thing is that I think it's 20 states plus the District of Columbia, it was already illegal to discriminate on the basis of sexual orientation, including in New York, where Mr. Zarda was the flight instructor. State law would have prohibited that too. So at-will employment, you're not protected if you're subject to at-will employment.
Well, you are if you prove that they fired you for the wrong reason, for an illegal reason. That's
an illegal reason, but it won't be illegal, I guess. I just wonder.
No, it is illegal. I mean, you can't fire somebody for being black. just because you're in an at-will state, that's a violation.
Well, because most states have prohibited that as a matter of statute. But I'm saying in the 30 states that haven't yet built sexual orientation into their own anti-discrimination statutes, although maybe they'll start reading it into their sex discrimination.
It doesn't really matter whether they do or don't. If you face that situation in any state in the country, you go to the EOC, you file a claim, and you have a Title VII claim.
No, I'm saying for employers fewer than 15 employees.
Oh, I see. Okay, sure. Okay.
The ones who are not covered by Title VII.
Yeah.
I'm not sure how many employees that is. And on the religious exemption question, one thing I'm really uncertain of is how many employers in the country, other than religious organizations, actually have policies against either transgender or gay and lesbian employees. As you and I know, they do in fact discriminate against them all the time. Some employers or supervisors or one bad person in the organization. But there aren't a whole lot that are like what Justice Alito was imagining, like a no gays allowed sign on the outside.
Right. No, but it tends to be things like hostile work environments where the person perceived as being gay is hounded out of the job, that sort of stuff. So it is a major problem, which has now been rather remarkably addressed by the extension of federal law to cover in all 50 states discrimination against transgender people, against gay and lesbian people, bisexual people, everybody. And so I want to say thank you to my friend Marty, and thank you to our great audience with the great questions. You have a final word of wisdom for us, Marty?
Oh, goodness. Well, I said I promised on Twitter I would talk about elephants, mouse holes. There's references to, they might have to wait till another podcast, talk about donut holes. Donut holes as well, and pirate ships, those all got in, but we might have to save all of that. These are justices who like to invoke very sort of evocative metaphors and hypotheticals. I'm not sure. I mean, I think this whole, I'll be interested to watch how this affects the so-called, right-wing movement in terms of judicial philosophy, if at all, or whether 10 or 20 years from now, this will be seen like all those other Title VII cases as a kind of like, duh, like, right. Yes, of course. Thank goodness we got over that and have moved on. Because I think there is a large consensus in the country that this is the right answer, but albeit with a substantial minority that is still mostly for religious reasons, very concerned about these sorts of things. So I'm afraid I don't have any brilliant words of wisdom. What about you?
No, I just think it's a great day for a group of people who are really left out there without protection in so much of the country. And I give a lot of thanks to the advocates who came up with this, going back to the EOC Commissioner Heifeld-Bloom, who basically took this theory and pushed it as hard as she could. And
our former colleague and our advocates and friends, David Cole, Pam Carlin, their entire teams at the ACLU and Stanford Clinic, and most importantly, perhaps, the plaintiffs, especially the transgender plaintiffs such as Amy Stevens, who were brave enough to challenge these things and who really did suffer for many years. It's a terrible tragedy that she didn't live to see this day. And neither did Zarda. He died in a
Mr. Bostock
skydiving accident. But Mr. Bostock is alive, thankfully. And it's, well, let me ask you this, Paul, to close. I was in the courtroom with you when the court announced the decision in Lawrence versus Texas, right? And there was a very large percentage of the LGBT Supreme Court bar was there.
Yeah.
They, along with many of the rest of us, were kind of breathless and in tears that we were trying to hold back during that.
Right.
Does this feel the same way? Does this,
no.
Do you think the community I think this is more surprising as a result than that was.
It's really more surprising, and it has an equally large impact on the lives of regular people out there. But the feeling of exclusion from the country, of being hatefully rejected in Bowers versus Hardwick, of being told nothing we can do to you is unconstitutional short of killing you, baby. And the sense that they were people without a country almost, and then having that apologized for by the Supreme Court of Lawrence was emotional in a very different way. And, you know, that was the point where the tide really started to turn for gay, lesbian, and transgender people. And the tide is still flowing. So happily.
Okay, final question for you then. 15 years ago, what would you have said the odds are that the results in Lawrence, Windsor, Obergefell, and Bostock would have all been, you know, seen by the year 2020?
I think in those days, people thought that we would get to marriage equality in maybe 15 or 20 years. It took a little less time than I would have predicted. In terms of the Bostock, the private employer discrimination rule, everybody thought that was going to be handled by, at some point, the Congress just passing a new law. In fact, I think people would have thought that would happen sooner. It didn't. It's just been stuck in Congress all these years. So anyway, a happy day, and thanks all for tuning in.
Thank you, Paul.
Do this again soon, I hope. Take care.